Chapter 2. Donor's Tax. Section 98. Imposition of Tax. A. There shall be levied, assessed, collected, and paid upon the transfer by any person, resident or non-resident, of the property by gift, a tax, computed as provided in Section 99. B. The tax shall apply whether the transfer is in trust or otherwise, whether the gift is direct or indirect, and whether the property is real or personal, tangible or intangible. Section 99. Rates of tax payable by donor. A. In general, the tax for each calendar year shall be computed on the basis of the total net gifts made during the calendar year in accordance with the following schedule. If the net gift is over but not over, the tax shall be plus of the excess over. P 100,000 exempt. P 100,000 200,000 0.2% P 100,000 200,000 500,000 2,000 4% 200,000 500,000 1,000,000 14,000 6% 500,000 1,000,000 3,000,000 44,000 8% 1,000,000 3,000,000 5,000,000 204,000 10% 3,000,000 5,000,000 10,000,000 404,000 12% 5,000,000 10,000,000 1,000,000 4,000 15% 10,000,000. B. Tax payable by donor if donee is a stranger. When the donee or beneficiary is stranger, the tax payable by the donor shall be 30% of the net gifts. For the purpose of this tax, a stranger is a person who is not a 1. Brother, sister, whether by whole or half-blood, spouse, ancestor and lineal descendant, or 2. Relative by consanguinity in the collateral line within the fourth degree of relationship. C. Any contribution in cash or in kind to any candidate, political party, or coalition of parties for campaign purposes shall be governed by the Election Code, as amended. Section 100. Transfer for less than adequate and full consideration. Where property, other than real property referred to in Section 24, d, is transferred for less than an adequate and full consideration in money or money's worth, then the amount by which the fair market value of the property exceeded the value of the consideration shall, for the purpose of the tax imposed by this chapter, be deemed a gift, and shall be included in computing the amount of gifts made during the calendar year. Section 101. Exemption of certain gifts. The following gifts or donations shall be exempt from the tax provided for in this chapter. A. In the case of gifts made by a resident. 1. Dowries or gifts made on account of marriage and before its celebration or within 1 year thereafter by parents to each of their legitimate, recognized natural or adopted children to the extent of the first 10,000 pesos, P 10,000. 2. Gifts made to or for the use of the national government or any entity created by any of its agencies which is not conducted for profit, or to any political subdivision of the said government, and 3. Gifts in favor of an educational and or charitable, religious, cultural, or social welfare corporation, institution, accredited non-government organization, trust, or philanthropic organization or research institution or organization, provided, however, that not more than 30% of said gifts shall be used by such donee for administration purposes. For the purpose of this exemption, a non-profit educational and or charitable corporation, institution, accredited non-government organization, trust, or philanthropic organization and or research institution or organization is a school, college or university and or charitable corporation, accredited non-government organization, trust, or philanthropic organization and or research institution or organization, incorporated as a non-stock entity, paying no dividends, governed by trustees who receive no compensation, and devoting all its income, whether students' fees or gifts, donation, subsidies, or other forms of philanthropy, to the accomplishment and promotion of the purposes enumerated in its articles of incorporation. B. In the case of gifts made by a non-resident not a citizen of the Philippines. 1. Gifts made to or for the use of the national government or any entity created by any of its agencies which is not conducted for profit, or to any political subdivision of the said government. 2. Gifts in favor of an educational and/or charitable, religious, cultural, or social welfare corporation, institution, foundation, trust or philanthropic organization or research institution or organization provided, however, that not more than 30% of said gifts shall be used by such donee for administration purposes. C. Tax credit for donors' taxes paid to a foreign country. 1. In general, the tax imposed by this title upon a donor who was a citizen or a resident at the time of donation shall be credited with the amount of any donor's tax of any character and description imposed by the authority of a foreign country. 2. Limitations on credit. The amount of the credit taken under this section shall be subject to each of the following limitations. A. The amount of the credit in respect to the tax paid to any country shall not exceed the same proportion of the tax against which such credit is taken, which the net gift situated within such country taxable under this title bears to his entire net gifts, and b. The total amount of the credit shall not exceed the same proportion of the tax against which such credit is taken, which the donor's net gifts situated outside the Philippines taxable under this title bears to his entire net gifts. Section 102. Valuation of gifts made in property. If the gift is made in property, the fair market value thereof at the time of the gift shall be considered the amount of the gift. In case of real property, the provisions of Section 88b shall apply to the valuation thereof. Section 103. Filing of return and payment of tax. A. Requirements. Any individual who makes any transfer by gift, except those which, under Section 101, are exempt from the tax provided for in this chapter, shall, for the purpose of the said tax, make a return under oath in duplicate. The return shall set forth 1. Each gift made during the calendar year which is to be included in computing net gifts. 2. The deductions claimed and allowable. 3. Any previous net gifts made during the same calendar year. 4. The name of the donee, and 5. Such further information as may be required by rules and regulations made pursuant to law. B. Time and place of filing and payment. The return of the donor required in this section shall be filed within 30 days after the date the gift is made, and the tax due thereon shall be paid at the time of filing. Except in cases where the Commissioner otherwise permits, the return shall be filed and the tax paid to an authorized agent bank, the Revenue District Officer, Revenue Collection Officer, or duly authorized treasurer of the city or municipality where the donor was domiciled at the time of the transfer, or if there be no legal residence in the Philippines, with the office of the Commissioner. In the case of gifts made by a non-resident, the return may be filed with the Philippine Embassy or Consulate in the country where he is domiciled at the time of the transfer, or directly with the office of the Commissioner. Section 104. Definitions. For purposes of this title, the terms gross estate and gifts include real and personal property, whether tangible or intangible, or mixed, wherever situated, provided, however, that where the decedent or donor was a non-resident alien at the time of his death or donation, as the case may be, his real and personal property so transferred but which are situated outside the Philippines shall not be included as part of his gross estate or gross gift, provided, further, that franchise which must be exercised in the Philippines, shares, obligations, or bonds issued by any corporation or sociedad anónima organized or constituted in the Philippines in accordance with its laws, shares, obligations, or bonds by any foreign corporation 85% of the business of which is located in the Philippines, shares, obligations, or bonds issued by any foreign corporation if such shares, obligations or bonds have acquired a business situs in the Philippines, shares or rights in an partnership, business, or industry established in the Philippines, shall be considered as situated in the Philippines, provided, still further, that no tax shall be collected under this title in respect of intangible personal property. A. If the decedent at the time of his death or the donor at the time of the donation was a citizen and resident of a foreign country which at the time of his death or donation did not impose a transfer tax of any character, in respect of intangible personal property of citizens of the Philippines not residing in that foreign country, or b. If the laws of the foreign country of which the decedent or donor was a citizen and resident at the time of his death or donation allows a similar exemption from transfer or death taxes of every character or description in respect of intangible personal property owned by citizens of the Philippines not residing in that foreign country. The term deficiency means a. The amount by which tax imposed by this chapter exceeds the amount shown as the tax by the donor upon his return, but the amount so shown on the return shall first be increased by the amount previously assessed, or collected without assessment, as a deficiency, and decreased by the amounts previously abetted, refunded, or otherwise repaid in respect of such tax, or b. If no amount is shown as the tax by the donor, then the amount by which the tax exceeds the amounts previously assessed, or collected without assessment, as a deficiency, but such amounts previously assessed, or collected without assessment, shall first be decreased by the amount previously abetted, refunded, or otherwise repaid in respect of such tax. ______.